Lords, I'll begin by just for completeness handing up the current provision of the Solicitors Act, which replicates the privilege provision that I've been talking about. I will hand it up. Thank you. And I suggest that goes at tab 7 of your supplemental bundles.
Thank you.
Just before you put it there, might just be worth pointing out, it's subsection 11.
Where's it going?
It's going to tab 7 of the supplemental bundle, my lord.
The supplemental authorities.
Supplemental authorities. Sorry, yes.
Yes.
So just drawing your attention to the wording, which is materially identical to the provision of the Act that Lord Denning was looking at. No person shall be compelled under any such writ to produce any document which he could not be compelled to produce on the trial of an action. That's the same wording. Just picking up 2 or 3 minor points from before the shorter journal. My Lord Justice Lewison referred to the intellectually respectable route, or cogent route, I don't know what the word was, being consent implied. And if that were to be the route upon which this court landed, were they to be minded to, then we would say that exactly the same term would be implied into an entity with its auditor. And again, I'm not going to, it would be unwise of me to debate implication of terms with any of you, but when one looks at necessity, and one looks at the necessary override, or the necessity of implying a term, then I have set, reading Lord Hoffman's speech, that the threshold at reasonable. But to avoid any doubt, if the threshold is necessary, then we say it is just as necessary for the FRC as it is for the SRA, because obviously this issue will only arise in cases where there are relevant client privilege documents, potentially relevant client privilege documents. That does often arise. And if the FRC is properly to regulate auditors, and to be fair to auditors, then it is important that it is able to see, it is necessary, vital that it is able to see everything the auditor saw or ought to have seen.
Did you manage to find look at?
We did look, my lord, and we haven't found anything.
I don't think there is.
No, but we don't either. But my lord, the Master of the Rolls pointed to Lord Hobhouse's speech earlier and asked about the potential for him not having endorsed Lord Hoffman's reasoning. I didn't point you then to paragraph 48. I needn't turn you to it, I can just read the very short section. There were cited to your lordships decisions of the courts of other common law jurisdictions, which have also arrived at conclusions very similar to those of your lordships in this case. I don't wish to add anything to what my noble and learned friend has said in this connection, nor to what he has said about the English authorities, which will now have to be read with the judgment of this House. So that's 48 of Lord Hobhouse's speech. And it looks as though that's a reference to Parry, Jones and Taylor. Picking up where I finished before the adjournment. I mentioned 7 days being it is in fact the minimum notice that the FRC will give, and it is not 7 days to get a whole process of an injunction up, running and finished. It's 7 days to have a negotiation about it, and that's a minimum. If no negotiated settlement can be arrived at, the entity can then issue proceedings which will stop the clock. Coming back to this point, just want to make one further point on anonymisation of regulatory outcomes, and as to whether any anonymisation is necessary in order to avoid the contemplated harm of adverse publicity. Much will depend on the facts of the individual case. For instance, if there were relatively minor findings against the auditor or the accountant, if the privileged material is used in the accountancy investigation, to which I'll come next, then it might be thought highly unlikely that that would lead to any adverse publicity to the company. Likewise, if there were, for instance, numerous findings based on non-privileged material, but one based on privileged material, it might be thought that any additional prejudice would be either non-existent or non-material. And depending on the facts of the individual case, the FRC or the court, if the FRC's decision were challenged, might consider that an appropriately worded disclaimer would either neutralise or reduce the risk in the particular circumstances of the case. I want to move on now. I've dealt with
Do the regulations say anything about publication?
yes, they do. That's the regulation I gave your lordship.
Regulation 6, was it?
Yes. So I can go to that if that would assist.
Where do you find that?
It's at page 67 of Authority Rule 1, tab 5. Internal page 13 of the document. So, shall publish the outcomes of details of sanctions imposed, and what details must be published, and the circumstances in which A's identity must not be published. And the most important one for these purposes is D, where the publication was called disproportionate damage to any institution or individual involved. And we say any infringement of their human rights would be a disproportionate damage. And the directive which underlies these makes it clear that publication should not take place if it will infringe a human right. The passage I referred to.
This is only concerned with publication of draft forms. It's not concerned with publication of Sports Direct.
No, it's not. It's when what Sports Direct complain, it will be the potential damage is a regulatory outcome against GT. They're sanctioned, and it's said that Sports Direct are the auditors, or in this particular case, because the facts of the investigation have been published in the sense of it's happening, you could join the dots and see that it's them. So, but it would be against GT. It wouldn't be published against Sports Direct. It would be the finding against GT, hypothetical finding, because there hasn't been one. But if it happens and there is one, then the sanction will be published, and Sports Direct say that will harm them.
Yeah. Which regulation was that? 6.
6, yes.
Can I just pick up one thing? I'm not in any sense doubting it at all, but
the material you've given us about why it's necessary for the regulator here to have this material, is that in evidence anywhere? Or
No.
that you're just saying? I
No.
don't know, it may not be disputed.
No, my lord.
So
We
the
merely
judge
said-
didn't go into that.
The judge didn't go into that.
And
We
there's
didn't
no
get
evidence.
into this because he followed the Morgan Grenfell dictum and didn't discuss this, and it wasn't discussed below.
Right, thank you.
So I'll move on to the point made about the accountancy scheme. What is said about the accountancy scheme, in essence, is that if privileged material obtained under the SATCAR regime is used against the subject B, and there is an adverse regulatory outcome, then in essence there's all the more close association between SDI and subject B rather than being separate entities, and therefore there's a greater risk of harm. Now the overarching point I make here is that the same applies, that can be neutralised and would be neutralised by anonymization. So that's the overarching point.
Well, isn't there an anterior point? One of them, you are saying that your reading of the regulation, based on the Morgan Grenfell dictum, is justified by the fact, amongst others, that the FRC cannot use the LP material for any purpose other than the SATCAR investigation. So you've first got to show, have you not, before we get on to neutralising harm, that the FRC are entitled.
Absolutely, my lord. It's
Right.
but where I'm going. I just wanted to make the overall point that if the point is successful, then if the material can be used and is used, that the harm can be neutralised. But that's the starting point, of course. So, as a preliminary, it's important for me to establish that, leaving aside the privilege issue for the moment, that the FRC is entitled to use material obtained from the auditor or from anyone else under SATCAR in its investigation under the accountancy scheme. And the route for that is section 1224A of the Companies Act, and that's at Authorities 1, tab 4. Tab 4. And the internal page is 22. Now, my lords, this is it's a step in the reasoning, but Sports Direct has not sought to bring proceedings forbidding the FRC from doing this, and we say if they did, then this is the answer to it. So, restrictions on disclosure. This section applies to information in whatever form, B, relating to any particular business, that is provided to a body to which this section applies in connection with the exercise of its functions under, and then you could skip the next bit and go to SATCAR. So it applies to information relating to any business that's provided to a body to which this section applies, or return to that, in connection with the exercise of its functions under SATCAR. This section applies to a recognised supervisory body, a recognised qualifying body, and the competent authority and the independent supervisor. Now, for present purposes, the first three are the relevant ones because the FRC exercises its powers under the audit scheme as the competent authority under SATCAR, and it exercises, under various arrangements with the supervisory bodies, the accounting bodies, the powers that it exercises delegated from them to discipline accountants. So it applies to the recognised supervisory bodies, recognised qualifying body, the competent authority. And then subsection 3, no such information may, during the lifetime of the individual, or so long as the business continues to be carried on, be disclosed without the consent of that individual, or, as the case may be, the person for the time being carrying on that business. And then we get to the exception. Subsection 3 does not apply to any disclosure of information that is made for the purpose of facilitating the carrying out by the body of any of its functions. And those are the function qua competent authority and qua delegated authority from the recognised bodies carried out by the FRC. That's the statutory route to use by the FRC in the accountancy scheme. And if that route weren't there, it would make the FRC's life very difficult, because it would be very difficult to investigate an accountant if you couldn't use non-privileged at the moment, this is stage 1, the non-privileged information that you obtain from the company. So that's the statutory route, and that establishes that absent considerations of privilege, the FRC is entitled to use information from obtained under SATCAR in relation to the accountancy scheme. Now, the next question is whether it can use any privileged material it obtains under SATCAR.
Just before you leave that,
Yes.
It must be inherent in your submission that if the regulation of accountants were carried out by the Chartered Institute of Accountancy, that the FRC could pass, the FRC as competent authority could pass information to the Institute as supervisory body.
It is inherent in that.
Yeah. So that the bodies can swap information amongst themselves.
Yes.
Yeah.
The next question is whether the FRC can use any privileged material within the SATCAR material. And our submission on this is that if we are right that the Morgan-Grenfell principles apply, or any other principle that your lordships and your ladyship may articulate, such that it can use privileged material in relation to the auditor, then by parity of reasoning, it's obvious that that should also apply in relation to the accountant subject B. And on the Morgan-Grenfell reasoning, the reasoning is that you're going to fulfil the Morgan-Grenfell criteria, the 3 that I articulated for you earlier, that it's going to be used for a regulatory purpose, it's going to be confidential, and it's going to be not going to be used adverse to the interest, the entity whose privilege it is. In other words, we'll get on in a moment to I've come round full circle to the point I started with, in fact, which is we say it's not adverse use because you can mitigate, you can eliminate the risk by non-publication in ultimate cases, but that we say exactly the same applies logically to a regulatory investigation under the accountancy scheme, because it's not going to be used against SDI. It's going to be kept confidential, subject to the other caveats we've had, and it's used for a regulatory purpose.
Well, how do you know how they're going to use it?
In what sense, Manager? I'm sorry.
Well, if you're disclosing privileged material to somebody else.
No, that's. Can I come back to that, lady? This is where the FRC itself, its enforcement division, is using one of. I'm coming to an end point here, which is one of the complaints here is the enforcement. The accountancy scheme investigation team has an overlap with the audit scheme, or is the same team. The same applies. If there's an overlap, it would be the same problem. the complaint made is it's the same team. Now, we say that if the FRC is entitled to use the privileged material by the two stages that I've articulated in relation to, against the accountant, then there can be no possible mischief if the same team has all the material. It's only if that you could point to a situation in which they couldn't use it against the accountant that you have a same team or overlap of team problem. So once I've established, one, that you can use the material for the accounting scheme, and two, if I establish it, that by logical parity of reasoning, the privileged material can also be used, the same team or overlap of team problem that is articulated by Sports Direct simply falls away.
And this is, if I understood correctly, this is that part of Morgan Grenfell which talks about a technical breach authorised by statute. It's not the no infringement limit.
It is also the no infringement limit.
Well, I wonder about that, because in outlining your conditions for your justification for no infringement, you were talking about obligations to share material, not entitlements to share material, and there's no obligation that you've shown us thus far on the FRC to pass on material.
No, Lord, but I think we used the examples of. I used the example of national security. For instance, something came to the attention, there would be.
I thought that was an example of an obligation to pass on.
Similarly, money laundering, which we discussed.
Yes, I'm sorry, I'm missing the point. I'm clearly not getting the point. I'm sorry. So
your second non-infringement, you say, exists where the material is produced to a regulator and
yes.
is kept confidential, subject to law. I wrote down e.g. an obligation to
yes,
share,
yes.
not going to be used by the regulatory body against the right holder. But so, subject to law would include anything which permits the regulator to disclose, rather anything which doesn't forbid the regulator to disclose that material.
It means subject to anything that requires them to disclose, and otherwise they will keep confidential.
Yes, well that's what I thought, but there's nothing in the company's legislation you've shown us which requires the FRC pass on material either to another branch of itself.
No, there isn't anything that requires it to pass it on to another branch.
So does its ability to do so actually mean that you don't qualify under the three-stage test for the Hoffman dictum, because there is no bounds of confidentiality constraining the use of this material by the FRC.
But all regulators are under implied duty of confidentiality in relation to material supplied to them.
Well, what's the point of
Well,
this?
it's not. The point is, milady, that you can use this confidential material in the accounting scheme through the gateway of 1224A, but that doesn't involve you supplying it not being confidential. It's still confidential within the regulatory purpose of the
How many
SR.
people do you have to be entitled to tell before it stops being confidential? I don't see what meaning confidential has in
I can
that.
see my lady's puzzlement, which obviously means I'm putting it badly. But
No, you're not. But I don't see how you maintain that you can still fit in the criteria that supposedly limit the Hoffman dictum of no infringement, and also still claim to be entitled to pass this privileged information around other regulators or around your own teams, just as in the same way as non-privileged material.
Well, Melody, because it's confidential to that regulatory body, that was the wording I used. If it's used by the regulator itself, both for its audit enforcement procedure and for the delegated procedure under the accountant scheme, then that is still confidential.
But I think you also said that even if the accountancy scheme was being regulated by the Chartered Institute, you'd be entitled to pass on the information.
Under the obligation of confidentiality, because in that case, the Chartered Institute would be used to fulfilling the regulatory purpose.
And if the privileged material showed that something fishy was going on in the solicitor's firm, would you be able to pass it on to the SRA?
Well, my lord, that would depend upon whether there was a statutory requirement to do so. I can't immediately think
A
that there would.
statutory requirement or a statutory power? There's never a statutory requirement or only an
There is, my lady. There are statutory requirements to pass on information, for instance, to the on anti-money laundering and on national security for certain bodies. There certainly are statutory
Yes,
requirements.
but you're not claiming that it's limited. I mean, I could understand your case if you were saying, yes, we have these wide gateways for non-privileged materials, but we fully accept that if we take privileged material from Grant Thornton, we can only use it for the SAPCAR investigation, and the only inroad to that is where we are obliged as a matter of law to pass it on to some kind of body. If that was your submission,
Yes,
which
ma'am.
is what I was expecting you to say, I
Yes.
must say, that would have some kind of coherence. But with respect, I don't see that you can both claim to be bounded by confidentiality and bound only to use it for the purpose for which it's given, as Lord Hoffman seems to envisage, and yet also claim to be able to rely on these very wide gateways.
My lady, the answer to that on coherence is that if we are wrong in relation to the accountancy scheme investigators being able to use it under the Morgan Grenfell principles, then that is perfectly right. Let's enter that world. So
Well, I'm not asking what would happen if you're wrong. I'm asking what is your submission as to what the case is.
If we are right, then it's being kept confidential within the regulator. The Morgan Grenfell principles mean that you can use it. This is ex hypothesi, and the Hoffman criteria are met because it's being kept confidential to the regulator. If I'm wrong on that, and the privilege attaches and we can't use it in relation to the accountancy scheme, then I accept that, and the answer to that would be that you would have to have information barriers. If you're against me on this, and if you say, well, we understand what you say about SAPCAR and the investigation, but we don't think that the Morgan Grenfell privilege point runs in relation to the accountancy scheme, then the only answer would be information barriers and separate teams. And the FRC would have to do that, obviously, or it would not be able to continue the investigation. When one's told that the submission is not coherent, my lady, it troubles, and I wonder if that meets your ladyship's point.
Yes.
I'm grateful.
Again, I don't want to be nitpicking about this, but is any of this dealt with in the evidence?
I'm sorry, my lord, I missed that.
Is any of this dealt with in the evidence? No, I'm not trying to be nitpicking.
No,
I want to know if
it's points of principle, my lord.
So, but this description about that it would be the same team, or if this happened,
my lord,
you'd have different teams. And all that sort of
we
stuff.
know and we accept that at the moment, and Mr Lissack jumped when I said overlap of teams, the same team is currently dealing
That is
with
in the evidence, actually.
that is in the evidence. Yes, that is, and it's common ground.
Got his name at the
Yeah,
partner in RBC, makes that precise complaint.
That he does make that complaint. It's in the evidence, and we accept that.
So
but,
that's the same teams in evidence.
I'm reminded, my lord, that the FRC does have protocols in place whereby it does not voluntarily provide privileged material to other regulators. It would have to be compelled to do so, and if it were compelled to do so, then it would obviously that would have to be the ultimate arbiter. That would have to be the court.
That's the sort of self-denying order.
Yes. Might I have a moment? So
Right. Have we, so have we now
we
dealt
have
with harm?
dealt with that point, my lords, my lady. So the reasoning is there's a statutory gateway to use material in the accountancy scheme. If the Morgan-Grenfell criteria or any other criteria that your lordships find mean that privilege is not infringed, privileged material can be used under SATCAR, then the same rationale exactly applies under the accountancy scheme, and therefore there's no same team problem, there's no confidentiality problem, because it is still confidential to the FRC. I move on to the next obstacle that's put in our way, and a point which didn't arise before the judge. Now, the separation between there's another division of the FRC, the corporate reporting review division, and that does have powers to act adverse to Sports Direct. Now, if and therefore we accept that privileged material cannot go to it and should not be used by it. Now, this point didn't arise before the judge because the enforcement team of the FRC, who had been involved in this investigation, didn't have in mind the powers of the CRR powers, and it was in preparing the appeal that the light bulb went on, and someone said, "Hold on a minute. There is a power within the FRC to act adverse to Sports Direct." It's been used, in fact, in the sense that there have been CRR investigations into Sports Direct, I think in the 13 and 14 years, with no power exercised against them. Everything was found to be in order.
This is another statutory function, is it? That's conferred on the SRC
Yes, this is another statutory function.
under the Companies Act? Or
I'll check that, my lord. But yes, it's another function that they fulfil.
does in its capacity as exercising that function,
Yes.
does it have powers to require documents?
Yes.
as well?
Sorry, it has what the main power it has, which has actually never been exercised, is that it can go to court and seek an amendment of a company's accounts, but it's perfectly possible to exercise it, and it may well happen. And so it's accepted that, or at least proceedings have been contemplated in this context, but there's no decision of a court in which the power has been exercised and found to be an account's found to be defective and needing alteration.
So
Yet.
in theory, is this possible that the FRC investigates Grant Thornton, it finds they should have put a note in the accounts about related parties, it can then go to court to require Sports Direct to change its account to insert the note which the FRC says Grant Thornton ought to insert. Is that sort of how it works?
Well, it's slightly different from that, my lord, in the sense that if the FRC did receive privileged material which led to that conclusion, then by definition we accept that the corporate reporting review body could not use that because it would be use adverse to Sports Direct. And so what I didn't go to the draft undertakings because what happened was that the FRC offered undertakings in essence to ensure no overlap of information and no use against Sports Direct by CRR. Whereas I say it's perfectly fine under the Morgan-Grenfell or other principles to share it with the accounting scheme and use against subject B. It is absolutely not fine for CRR to use it because that is adverse to Sports Direct. That's the key thing. So
if we envisage the situation that my Lord Justice Lewison envisages, that you get this privileged information, you use it against Grant Thornton, and then your corporate review team goes to court to
it won't and it can't.
Well, just wait a minute.
sorry,
It goes to court and says to the court, please make an amendment to your company's accounts. And SDI say, well, wait a minute, you can't do that because you promised not to use the material, to which the corporate review team say, well, we didn't use the material, we're basing it on other things. How is anyone to establish whether or not you did abide by that obligation
I mean, a couple of things.
without disclosing the privileged material?
My lady, the corporate reporting review body would have to be able to say, we did not use any, as a starting point, we did not use any privileged material or rely upon any fact derived from privileged material, or make a similar declaration. And if they couldn't make it, then they couldn't make the application. But in a sense, I suppose one answer to that is that a regulatory body, at least to some extent, has to be trusted to abide by its undertakings. And if it undertakes, it offered an extensive undertaking in relation to not using the material or supplying it to anyone. Sorry, Ronald?
Where is it?
It's in the bundle, in supplemental bundle.
Slight air of unreality about this. I mean, the corporate reporting review will say, well, look, we looked at the funding made by the FRC on its website. The finding against Grant Thornton was this, that, and the other thing. We can see from that there was material made in the accounts. We don't know what material Grant put at the FRC in its capacity as competent authority to use, but that's the outcome. That's
Well, my lord, it's always possible to construct an example in which there's a possibility of privileged material coming somewhere into the chain. And one can construct an example, but the complaint made, if I may go back a bit, the complaint made is that CRR could use material against Sports Direct. It may be that my Lord Justice, the Master of Rolls, request to see the undertaking is the point to go to this here, because if we look at the undertaking that's been offered, and clearly it's always possible to improve these things. 297 of the tab 27, page 297 of the supplemental bundle. 297. Sorry. You should. This is the development. Sure. What page is it, Richard? 285. Fine.
Thank you.
There's an earlier iteration of this at 285, my lords, but what happened was that the FRC wrote to Sports Direct solicitors saying, this has occurred to us, and this is how we propose to deal with it by an undertaking. Sports Direct solicitors said, no, that's not good enough. So, for various reasons, an amended undertaking was offered, and the response from Sports Direct has been, no undertaking can ever be sufficient. So
297 is the current proposal.
297 is the current proposal, but my lords, I stress this, that if this court believed that that undertaking was inadequate in any way, then it could clearly be amended. It is the best that the FRC can do at the moment. I'll just let you read it if I may. So, my lords, my lady, that there is no overlap in teams here. The submissions that my learned friend made yesterday were based on the overlap in teams between the accountancy scheme and the audit scheme. CRR is separate, and it offers this undertaking, or any undertaking the court may think would enable this to happen. If the court finds, of course, that per Sports Direct submission, that cannot occur, there is no undertaking which will meet the problem or the issue, then so be it. But that is the suggested solution to that point. And if it is taken as a stumbling block, then it will mean that means that the information, privileged information, can't come to the FRC either as its audit function or its accounting function. Then that will be a very significant problem for the FRC, because many audits involve auditors seeing privileged material, and the FRC won't be able to see it if that were the ultimate conclusion. So we say the fact that it has different arms shouldn't mean that the remote possibility, it could be the CRR function, my Lord, Lord Justice Lewison said, that was exercised by a completely separate body, but that wouldn't meet your Lordship's example of an indirect chain, whereby the separate body says, well, you said they've got to correct the account, there should be a related party disclosure, so we're going to go to court and say you should do it. But underlying that, you've perhaps got privileged material. That wouldn't be met even by having a completely separate body. That objection.
Can I just, you're quite discursive, so can I just summarise what I understand your submission to be on this part of the case? First of all, in relation to anonymization, you said, well, it all will depend on the facts, and it might be possible, it might not. It depends whether it's necessary, I think is what you're saying.
It will always be possible, but whether it's necessary will depend on the facts, and if it is to stop a human right...
It's always possible, but whether or not necessary will depend upon what the findings are.
Yes.
Right, that's the first point. The second point then you had relates to the overlap. And there you say, as I understand it, it's the same team. I made the point it's the same team, and they're all bound in relation to both the audit investigation, the AEP and the AS. They're bound by their obligation of confidentiality.
Yes.
So that's your point there on that particular.
There's a second limb to that, my Lord, if I may say,
Right.
which is that if I am right that both the audit and the accounting team can use the privileged material, then there is no problem with the overlap. In other words, if you've got a situation where all the material is open to both teams subject to confidentiality, then there's no problem with the overlap of teams. If you were to find that the Morgan Grenfell or other principle doesn't run in relation to the accounting scheme for some reason, then we accept that the only answer would be a separate team with information.
So it's the same team, one which the same team which, in respect of those different functions, is bound by the dictum,
yes,
to which the dictum applies. And secondly, I think also there's another limb to that, and is bound by confidentiality.
Yes.
Plus bound by confidentiality. Right, that's that bit, and that deals with that overlap. And then, so far as other functions are concerned, particularly the CRR, you say there would not be there are no circumstances in which confidential documents would be passed to the CRR, because that would enable it to use them against SDI,
yes,
and that's something that would not be contemplated.
yes, privileged documents. Yes.
Is that a fair summary of those different points?
Yeah, and that the potential problem is dealt with by the undertaking.
Plus the undertaking.
Yes.
Plus the undertaking.
Yes, and
Yes.
my Lord Justice Lewison's example of indirect, very, very indirect use would not be met even by a separate body, because there'd be a risk of that.
Right, okay. So does that do with that aspect?
That does.
Right, good. What are we now going on to?
There's just one further point, and I don't think I need to take you to these authorities, but when we are considering any problem of information leakage, which we might be in two scenarios. One, if you can use privileged material for the audit scheme, but not the accounting scheme. And two, if you're concerned about the CRR issue. My friends suggest that the threshold for the whole thing not being possible is the bulkier, well-known bulkier threshold. I needn't go to it looking at the time, but we have put in the authorities bundle two authorities which say that bulkier and that high threshold, or very low threshold, I suppose you could look at it as, for not being able to act, applies in the solicitor's context. And it doesn't apply, not that it doesn't apply in other contexts, but that is the context in which it has been applied. And the two cases are tabs 1 and 2 of the supplemental authorities bundle. So my friend didn't mention bulky R. I don't know whether he will, but that's the point. I have gone against Mr. Lewison.
Okay, let's move on to the next point.
Yes. So ground 3. We've dealt with the technical breach issue at some length. The other issue outstanding, which I haven't dealt with, is the point about 1/8 of the Schedule 2. So I'd like to come to that.
Yes, thank you.
And for that we need to go back to SATCAR, tab 5 of the first authority bundle.
You say that we've brought in the Morgan Grenfell dictum, the explanation of there's a distinction to be drawn between the subject's own LLP and the LLP of third parties. That's how they explained the similar provision in the Solicitors Act. Therefore, paragraph 1/8 of Schedule 2 applies only to Grant Thornton's own LPP, doesn't apply to LPP of anybody else.
Yeah.
That's it, isn't it?
That's it. The purpose recognised by Lord Denning of the section of the Solicitors Act is to say really that the usual rules of privilege apply, and that in this context, yes, the rules apply, but there's either no infringement or there's a technical breach.
I mean, the judge glossed that slightly by saying that if SDI had themselves been contemplating a claim against Grant Thornton, their LLP might be preserved. But that's not the way that Lord Hoffman or Denning.
No, and it's difficult to see why that would be ever relevant to the exercise of the FRC's statutory functions, which would depend upon what the auditor at the time knew or ought to have known. What FRC's lawyers were or were not advising them about the competence or otherwise of Grant Thornton would be nothing to the point. So even if there were some statutory override there which we don't assert, then it wouldn't be relevant to the audit investigation. because what SDI was saying to its lawyers about a potential claim against Franz Thornton is nothing to the point. What matters in a regulatory investigation, what's important to it, is that the FRC should be able to get either contemporaneous material from the time of the accounts, because that's the way in which a professional is judged, the knowledge at the time, or constructive knowledge.
That's a
Sorry, I don't know.
distinction with a very bright line, which is quite difficult to draw, isn't it? Somebody from SDI writes to their lawyer saying, "You remember you told us we had to disclose this to Grant Thornton? Well, we did, and they didn't put it in our accounts, and now the FRC are investigating them. What do you think we should do about that?"
Well, when is this letter being written, my lord?
Well,
So it's evidencing, so the hypothesis is that it's evidencing contemporaneous conversations which would not otherwise
privileged letter.
be in evidence. So I'm not quite clear, my lord, and I may have misunderstood what passage of the judgment your lordship's thinking of, where the judge said this, and what is troubling your lordship about it.
Towards the end, I think. It's paragraph 91, page 103 of the small bundle. And your submission is recorded as giving the example where SDI was contemplating a claim for negligence.
Sorry, yes. 18, sorry, my lord.
Legal advice as to the merits of that claim. You are then recorded as submitting in those circumstances SDI.
Sorry, my lord, I'd misunderstood your lordship. Yes, you would say it's not being used adverse to SDI in those circumstances.
But so are you saying that 1.8 has no application because the only thing it covers is Grant Thornton's ability to refuse to produce to the court its own material, its own privilege,
or the ability of the other people who are covered, for instance, under 1.4. So there are third parties in addition to the public interest entity who are covered by this.
Yes.
And so we give examples of how that would bite in relation to them, potentially.
I still don't understand that why 1.8 is not an answer to this case. Why is it that, how is it that you interpret that as meaning that it doesn't entitle SDI to refuse to produce the privileged material?
What we say, the first thing we do, my lady, is we point to the analogous provision in the Solicitors Act, and we say that didn't prevent Lord Denning or Lord Hoffman articulating principles whereby the material...
Right, but that related to the disciplinary tribunal hearing. It wasn't related to the call for documents.
No, but it doesn't matter in our submission whether it refers to the disciplinary tribunal or not. The fact is, what is being said is that the privilege is not infringed in the disciplinary tribunal. In principle, it is not infringed because, despite that provision. So the situation envisaged is that Lord Denning says that despite this saving provision, because the ultimate end of a regulatory investigation is a disciplinary tribunal.
Can we go back to what you said, actually? Can I just...
Yes, certainly.
Thank you.
Parry Jones. So it's on 110 of the authorities bundle, and what he says is at page 8 of the report, and as you'll remember, Mr Parry Jones' submission was that the rules were ultra vires because of 46.6.
Yes.
So Lord Denning says by a different route from Morgan Grenfell, well, you have an override, and that despite the fact that in all other respects the usual rules of legal professional privilege apply. And we say that these types of provision, and it's a standard wording, and there are other examples in the bundle, what they mean are, in essence, the usual rules of legal professional privilege apply.
I'm so sorry, I've got you've referred to page 8.
8 internal of the Parry Jones decision.
Where is it?
Halfway down.
Halfway down.
Between C and D. It's the line and a half at the end of the paragraph, isn't it?
Yes. I'm sorry if I'm moving too quick.
So I thought you were going to refer us to something which expressly referred to the equivalent provision.
Sorry, my lord. What I'm 46.6 is very similar in its
Well,
terms
let's look at it.
to, yes, I took you to it earlier and I handed up the new version of it earlier this
So
afternoon.
it's not actually in the case. It's not set out in the case.
No, it's not set out in the case.
Right. Let's see which tab is that.
It's
Well, let's
tab
have
1.
one. Fire is disintegrated at this point. Right, it's 46.
That's dealing with issuing writs of subpoena ad testificandum and duces, or however you pronounce
Yes,
it, tecum,
yes.
saying that
Issue writs of subpoena, having a duty to deliver to produce such writ, and he could not be compelled to produce on the trial of an action.
This is saying in disciplinary proceedings, if you're summoned to produce documents, obviously the ultimate end of any disciplinary proceedings is a tribunal if there's no settlement. So can you be compelled to produce, to bring privileged documents with you to the, or can you rely on in the tribunal proceedings? And what this says is that you can't be compelled to produce any document which you couldn't be compelled to produce on the trial of an action. And we say that's a very similar wording and is aimed to do the same thing, same work as in an action in the High Court. I don't want to misquote.
A complaint about a solicitor.
Yes.
The Law Society investigates, finds that there is a case to answer, takes the solicitor before a disciplinary tribunal, issues a writ of subpoena duces tecum against the client to prove its case against the solicitor. The client can't be made to produce any correspondence seeking legal advice with the solicitor under investigation.
Neither the client nor the solicitor can be.
So the distinction then between solicitor's own LLP and
Yes.
client's LLP is not a coherent one, because the client can't be made to give up material covered by his own LLP under section 40, whatever it is, 46.6.
At the moment, perhaps the incoherence is not striking me, but why is it sorry, well,
Well, the distinction that was being drawn was saying 46.6 protects the solicitor's own LLP, but doesn't protect the client's LLP, but you would only be issuing summonses of subpoena ad duces tecum against the client.
well,
You wouldn't be summoning the solicitor to give evidence.
My Lord, the way Lord Denning reads this, and we say that it's the correct way, is that in all other respects than the derogation he gives, the usual rules of professional privilege apply, and therefore that the derogation, that it is clear that he thinks the derogation is compatible with this section. So if the usual rules of professional privilege apply, which is what Mr Parry Jones was saying, the usual rules apply, and therefore this section's ultra vires, Lord Denning says, well, the usual rules do apply in every other respect. The rules of professional privilege apply. That's what this section is saying. It's a standard section importing the usual rules of legal professional privilege. And yet, you can have this derogation. And Lord Denning in Parry Jones thought that even with the usual rules of professional privilege applying, you could get the documents. And Lord Hoffman, seeing Parry Jones and seeing the fact that Lord Denning thought that under 46.6 the usual rules of professional privilege apply, thought that it was okay thought the non-infringement principle ran and the technical breach principle ran. So he obviously didn't think that the fact that the usual rules of professional privilege apply was a barrier to his route. And what we say is all 1.8 is saying is that the usual rules of professional privilege apply, but by parity of reasoning, that doesn't stop the Morgan-Grenfell principle running.
What he's doing here, surely, is quite. Surely, look, it's quite dead. It's quite a dense statement for what is quite a complex series of issues. What he's doing is he starts off by looking at the top of page 8, by looking at the accounts rules, which say that that's a rule pursuant to statute. Previously, and says I may have a missing page here. Just see 7. So he says under the statute, the council have made Rule 11.1 of the Solicitor Councils, which says, and then he says to produce his books. His books and so forth. So he says, well, that rule is a valid rule, which overrides any privilege or confidence which otherwise might subsist between solicitor and client, subject to whatever Lord Hoffman says later on. So he's saying that is a statutory override.
Yes.
And he says that is nonetheless has to be read together with 46.6.
Yes.
And he reconciles the two by saying it's a statutory override, but it doesn't go any further than the limited purpose for which it's to be used.
Yes.
Right, that's what it does. So what we're now looking at, I'm trying to relate it now to our situation and to Morgan Grenfell, is we're now looking at what you described, as I think, as the technical exception. We're not here dealing with no infringement point. We're now dealing with, is this right, that there is a statutory override. And the question you're being met with is to saying, yes, but how can that apply, that statutory override, when you've got the 1.8?
Yes.
So now we're looking, so the analysis that we're going through is you've got two statutory provisions. How do they operate together? Now, you say the first one of those statutory provisions, which is you've got to disclose, arises from the obligation to produce the books and documents, and you say that's a statutory override either because that's a reasonable implication, or if you need to do so, for the reasons you mentioned this afternoon, it is actually necessary. And so you're now dealing with a situation where that's the interpretation, but now how are we to reconcile that with 1.8 of Schedule 2? And you say, well, Lord Denning didn't seem to think that was a problem because he limited the disclosure for the purpose of he limited it for the purpose of the investigation, but for all other purposes it remains. And you say the same should apply in our case. Is that? I'm sorry to be rather slow about this, but it needs to be deconstructed. Is that the deconstruction?
Yes, that 1.8 is a similar provision to 46.6.
So 1.8 has to be read together with whatever the other provisions is, and the reconciliation of the two is to be done in the same way as Lord Denning did.
Yes, and Lord Hoffman clearly thought they were reconcilable because he didn't think 46.6, when expressed as the usual rules of professional privilege applying, was an obstacle to his interpretation.
Lord Hoffman or Lord Denning?
Lord Hoffman in Morgan Grenfell, when he's looking at Parry Jones,
But does he refer to section 46?
He doesn't refer to it, my lady, but it must be a premise of his that 46.6 doesn't cause that problem in Parry Jones. He must agree with Lord Denning, or he'd simply say, well, look, there's a big problem here because of 46.6. In other words, let's look merely at the solicitor's regime at the moment. Lord Denning thinks 46.6, which provides that in all respects, the usual rules of legal professional privilege apply. He doesn't think that's incompatible with his override reasoning. Now, by parity of reasoning, Lord Hoffman can't think it's incompatible either. He doesn't refer to it, but he knows it's there, and there will be a similar provision, and indeed there is a similar provision in it.
He didn't really. I mean, you don't need Lord Hoffman really.
I don't need Lord
because
Hoffman.
Lord Hoffman was merely concerned with the. He was concerned that really just having this rule, the solicitor's rule 11, whatever it is, 11.1 of the solicitor accounts rules, he wasn't convinced that that was a clear, on construction, a clear or by necessary implication, a requirement to ignore the whole of LLP. And so he wanted to find, that was what he was concentrating on. So he was trying to find some other reason to uphold the Parry Jones judgment. And he did it, you say, in the way, it's not an infringement or this bit about, it's, you know, it was sufficient. It was sufficient to exclude LLP to that extent. Yes, he doesn't really have to go on. He wasn't really going on to with anything else. That's what he was concentrating on.
Wasn't.
But you don't need that because you say it's sufficient. You've got Parry.
Yes, I do.
Which has been upheld.
Yes, I do. Yes, I do. Maybe I don't want to overcomplicate it. You know,
Well,
what's
what we're trying to avoid.
yes.
But so, did I misunderstand then? You're not making a point that 1.8 only allows Grant Thornton to object to producing documents in which it is entitled to claim privilege, but does not extend to allowing it to object to producing documents in which somebody else claims privilege.
1.8 does mean that Grant Thornton can object to producing documents subject to its own LPP.
So you are drawing that distinction.
Well, because the potential is that it's used adverse to Grant Thornton, and so the distinction.
Oh, I see. But you're not relying on any wording in the provision, but you're just saying that since the only get around for that is the Hoffman dictum, and since you treat the requirement that the documents must not be used adverse to them as equivalent to saying, so that means it's only, they must produce documents in which it's not their privilege, but only the client's privilege, that you accept that 1.8 does enable them to refuse to produce their own privileged documents because those don't fall within the Hoffman
So it's got some
dictum.
bite to it. I mean, it's not just redundant. So anyone who's ordered to produce documents can refuse to produce documents which are subject to their own LPP. Sorry, I misstated that. From the susurration on my left, I hear I misstated that.
It's becoming very complicated again.
Yes.
It feels.
So-
And
so-
I'm trying to keep it as simple as possible.
Yes. There's a
Can
qualification
you just
to that.
pose the position basically is Grant Thornton has some documents, and some of those documents are from its solicitors advising it.
Yes.
So that is Grant Thornton's own privilege.
Yes.
It also has documents which I thought were the ones you were really looking at and wanting, which are documents written to its client by solicitors, giving solicitors advice to the client.
Yes.
It also has those.
Yes.
Now, it obviously is bound by a duty of confidentiality regarding those, possibly arising out of its own relationship with the client, but certainly arising out of the fact that it is itself receiving what are confidential documents from the client. So you've got two categories of document there. What I would like to have in a very simple explanation,
Yes.
if it's possible,
Yes.
is what you say is the impact of 1.8 on those. I understand you to be saying, which is totally coherent, which is to say, well, because it would otherwise be a technical breach, Grant Thornton has to disclose. Well, it certainly has. I would have thought you would have said Grant Thornton has disclosed both of those, because that's what it's required by necessary implication or by reasoned inference from the obligation to produce all documents. But you don't seem to be saying anything as simple as that.
Well, if the documents aren't going to be used adverse to a party, then there is either no infringement. So 1.8 needs to be read as meaning that the usual rules of professional privilege include Morgan Grenfell.
Morgan Grenfell, basically.
Yes, the Morgan Grenfell points. So just as Lord Denning, when I said
So we say, can we not use it? 1.8, we're looking at this case, just this case.
yes,
So 1.8 applies, yes, in relation to Grant Thornton, is that it?
yeah, well, 1.8 would apply because the documents are being used adverse potentially to Grant Thornton, but they're not being used adverse to Sports Direct, and they're being the conditions that I set out earlier are, we say, satisfied, and therefore Sports Direct's privilege is not infringed, and therefore it wouldn't be entitled to refuse disclosure of those because the usual rules of professional privilege must be read in the light of the existing law of Morgan Grenfell.
Right.
But your non-adverse use point is limited, is it, to regulatory activity? Or is it not limited?
Yes, in the sense of representing the regulator, and I have talked also about other regulators such as the SRA, but the submissions that I'm making are confined to the regulatory context.
Yeah.
So what I've got, so where I've got to so far is this, that you need, that one, so far as 1.8 is concerned, so let's just take the Grant Thornton privileged documents, its own privilege.
Its own LPP, yes.
Its own LPP, you want those documents.
Let's say we want.
And you say, by virtue of statutory interpretation, not 1.8, but just by virtue of the obligation to produce the books, which derives from statute, you say you're entitled to that. Either because it's not a subject privilege at all, or if it is, it's the inference point.
Well, my lord, no, because with Grant Thornton's own legal professional privilege, the point is, if I, the regulator, am asking for Grant Thornton's documents in the context of a regulatory investigation,
Yes.
then the intention is potentially to use them against Grant Thornton. So the Morgan Grenfell exception doesn't apply.
And the technical breach point doesn't apply.
No. Nor does the non-infringement principle, which is based on the same adverse use principle.
Oh, I see, I see.
But we say Morgan Grenfell allows us, if I can correct the statement which caused the explosion to my left a few minutes ago, it allows us to get Sports Direct's privileged documents, the client privileged documents, because we have no powers against Sports Direct, subject to the CRR point we've debated. And so, because they're going to be kept confidential for regulatory purposes and there is to be no adverse use, they fall within one of the two limbs of Lord Hoffman in Morgan Grenfell, and therefore we can get them. And we say that what 1.8 means is merely that the usual rules apply, and the usual rules take into account Morgan Grenfell. And sorry, Melanie. And we say that Lord Denning in Parry Jones saw no inconsistency between a very similar rule, in which the usual rules of professional privilege were said to apply, and his override, which subsequently became slightly reinterpreted by Lord Hoffman in Morgan Grenfell. He saw no inconsistency with a very similar provision to 1.8 in saying you can have the documents. Morgan Grenfell reinterpreted Parry Jones and introduced the non-infringement principle, but Lord Denning didn't see any inconsistency between his override and the statute of very similar terms. By parity of reasoning, Lord Hoffman cannot have seen any insuperable obstacle in the fact that otherwise under statute the usual rules of professional privilege apply. We say that's all 1.8 does, and therefore 1.8 must be read subject to Morgan Grenfell, that being part of the usual regime, and therefore 1.8 is not a roadblock in relation to obtaining documents against which will not be used adverse to a party. It can't get GT's documents, LPP documents, because we are investigating GT, and therefore it is possible that we could use their documents against them.
So you don't fall within Lord
So we
Hoffman's
don't fall
you don't fall within the dictum.
and 1.8 bites on that.
1.8 bites on that.
Could I just check that I haven't gone entirely off piece there with Miss Loveridge? I'm told I haven't. With regret, I'll move on to subject to your lordships having any further questions. Move on to ground 4.
This is a communication.
Yes, it is. Now, following SDI's submissions yesterday and some viewing of YouTube to review them by Ms Loveridge, we understand SDI's position, so far as we can get it from those submissions, to be two-stage. When we're talking about the emails and attachments in the additional documents. And I'm sure Mr Lissack will correct me if I'm wrong. Each email and attachment is to be regarded, this is stage 1, as a single communication. Assuming the email is privileged, the attachment can also be withheld simply because it was attached to a privileged email. If they're right on this, then 2, in a normal disclosure exercise in court, there'll be a second stage at which the attachment will be considered a separate document, to determine whether it's disclosable as being in the power of the client, take into account both relevance and privilege. But here, SDI say there is no second stage because the FRC has asked for the attachment by reference to the email, the attachments by reference to the email. In essence, what they say is the FRC has asked for the single communication, which on their case is privileged. Now, SDI's case appears to be that even if they're wrong on the single communication issue, it's nevertheless entitled to withhold the attachments because, one, disclosing the attachment without the email would reveal the fact that the attachment had passed between the client and the lawyer, and two, in any event, the attachments are said not to be responsive to the notice of themselves. The only reason they're brought into the question is because of their attachment to the relevant email. They do not themselves, they say, meet the criteria in A to D of the notice. Now that's the way we understood the case. Now we say there are a number of...
That last point logically goes with the second point as you
Yes.
outlined it. What you call the second stage,
Yes.
the normal disclosure exercise. They say, as I've understood it, if you were to apply the second stage to this case, then because the attachments are not responsive to the notice, they thought they are in the same category as irrelevant
Yes,
documents
so there's a
or disclosure exercise.
Yes. That's their position. Yes. Now, I just want to make a general observation before turning to those points, because as was explored in Sports Direct's submissions yesterday, it may be the issue will only arise very rarely in civil proceedings. In the normal circumstances of a disclosure exercise, it's likely a copy of the non-privileged attachment will be separate from the email somewhere, and my Lord Justice Lewison gave an example of the only copy of a document sent in hard copy to a solicitor, and that will be a rare one. So in the normal scheme of things, you'll have an attachment separate, and that can be judged on its own merits. Now, the problem arises more often in a regulatory context, where a regulator's conducting an investigation and therefore seeking to identify for the purpose of serving a statutory notice documents likely to be relevant to its investigation with sufficient precision to enable those documents to be located and produced at a proportionate cost. But in circumstances where it has very little information as to what documents are actually out there. So unlike in a standard disclosure exercise, the regulator doesn't have the benefit of an obligation on the part of the recipient merely to conduct a proportionate search and then disclose any document which is relevant. You have to serve a notice which describes the documents, the custodians, etc. There's no separate test of relevance. If it's in the notice, you get it, subject to privilege. If it's not, you don't. So the question is whether the documents fall within the scope of the notice. Now, it's quite difficult for a regulator, therefore, to capture documents which they don't know exist. For instance, if we give the example of the so-called Deloitte material, we don't know originally, Sports Direct didn't know the date of the document, who drafted it, what it was, etc., etc. So when you have to, there's a sort of reversal of the burden of proof here. Instead of the client having to supply you with all relevant documents, you have to specify to the client, and that clearly causes some difficulties. Now, the significance, so I say that as a preface. Turning then to the arguments advanced by Sports Direct, the first point is the email and the attachment are not a single communication. And we say that Jet 2 is an insuperable obstacle here. Lord Justice Higginbotham considered the very submission which Sports Direct now makes at 104 and 105, and it's worth turning to it. I hope it's now here in the bundle. It's supplemental bundle 4, tab 4, I'm so sorry. So at 107, he says, he cites Venturis and Immerman, and says, in giving disclosures, some separate consideration of substantive documents and attachments therefore has to be undertaken. Whilst an email and attachment can be regarded as a single communication, separate consideration will need to be given to the attachment, given that it will have been received or created by the sender, and therefore may require discrete consideration. Now, so the answer to the submission made on behalf of the CAA was, therefore, a party can't simply rely on the fact an email is privileged to say its attachment is also privileged. Separate consideration has to be given to it. Now, STI seems to put its own gloss on this to say that separate consideration is only to be given to the attachment, and I think this is my lady's point, if it exists somewhere else as an independent document, and your ladyship asked some questions about that yesterday. Now, we say there's no support for this in the judgment of Lord Justice Higginbottom, or in principle. And STI says that the Jet 2 decisions obiter on this point, and we say that's not the case. Lord Justice Higginbottom said at 106 the ground didn't feature heavily before the court, and it didn't appear to bear on whether any of the relevant documents were privileged or not, but it was a freestanding ground of appeal which the Court of Appeal did determine, and where there appears to have been at least some possibility it would affect whether some of the relevant documents were privileged. Now, the second point that Sports Direct make is they say they can refuse to produce it because it would reveal the fact of communication of it to the lawyers. Now, Jet 2 is also of assistance on this, we say. The court was required to consider, among other things, whether a dominant purpose test applies to LAP, legal advice privilege, and the proper approach to be adopted when considering whether multi-addressee communications are protected by LAP, where they go around multiple addressees and say the lawyer is on it, on the chain. Now, the court held the dominant purpose test did apply, and in relation to multiple addressee communications, we turn to paragraph 100, Roman 4. And could I ask your lordships to read that paragraph? So we say...
Is he saying at the end of that paragraph, if the dominant purpose of the email is to settle the instructions to the lawyer, and it happens that they've copied the lawyer in as well, is that a dominant purpose which is privileged or not?
Well, the question is whether they've merely been copied by way of information, or
well, because he seems to be contrasting, one would think he was contrasting one situation where the dominant purpose is privileged with one where it's not.
Yes.
And the last one where it's sent to non-lawyers to obtain their substantive non-lawyer input, that sounds as if it's not the privileged one.
Yes.
So it sounds as if the first one, where it's sent to other people for the purpose of settling instructions to the lawyer, is privileged.
I'm not sure anything turns on that precise aspect of it, my lady. What we take from this is that the result is where there are multi-addressee communications sent from a client, for instance, a senior figure in the organisation, to a number of recipients, attaching a non-privileged document, it will be treated as if it was a number of separate bilateral communications. And the email sent to each non-lawyer recipient, together with its attachment, will be disclosable unless the dominant purpose was that of instructing, and this is the way we read it, instructing the lawyer, or the communications might realistically disclose legal advice. So the fact that it will be evident, this is the key point we rely on, the fact it will be evident on disclosure that the email and attachment had also been sent to the lawyer doesn't prevent the email and attachment as sent to the non-lawyers from being disclosable. That's the point we rely on.
Right. But why do you make that point?
Well, what appears to be said against us is what will be, because of the form of the notice, it asks for emails and attachments, and we've not got the emails and we've not got the attachments. If orphan attachments are sent to us, it'll be obvious in the circumstances of this case, it is said, that they were sent to the lawyers, and therefore, as I understand Sports Direct's case, it would reveal the fact that it had been communicated to the lawyers. Now, we say that's not an exception unless, in some way, per Lyle and Kennedy, it betrays the trend of legal advice, unless it tells you something about the advice. And so
That's a separate point.
That's
a much shorter point.
yes,
So the short point is, you say the mere fact that something's attached to something
yes,
doesn't in itself tell you anything. The fact that it's been sent to a lawyer doesn't communicate any kind of privileged advice of any sort.
no, it doesn't.
It's just a fact, like a chronology.
Yes,
We consulted the lawyer on that day.
yes.
That in itself, I'm not sure it's privileged.
Well, that's the case for against us.
But-
The fact it will be clear that it was attached, as I understand it. It may not be.
This is the attachment disclosing that there was that it was sent to a lawyer or received from
Yes.
a lawyer.
As I understand it, the case is that in the circumstances of this case, where we ask for emails attachments, we're told that the emails are privileged, and therefore we're going to get a set up, if we get them, of orphan attachments, that they should not be disclosed, because it would reveal the fact that those attachments had been communicated to the lawyers. Now, I'm not hearing any objection on my left to that being the way the case is put, but if that's the way the case is put, then we say that Jet 2 is of assistance, because it shows that even where you've got non-lawyers copied on with a lawyer, that that's not considered to be a problem. The mere fact that the attachment also went to a lawyer is neither here nor there.
Paragraph 100, subparagraph 4 is not dealing with attachments. It's dealing with emails.
Yes.
And what it's saying is that if you email around a number of people, either the dominant purpose is privilege or it isn't privilege, but the fact that one of the people copied in is a lawyer does not make that email non-disclosable, at least in the hands of the other people.
Yeah,
Whether you
no.
can require the lawyer to disclose it, I think is maybe a different question. But the fact that Mr Bloggins was copied in, who's a
No.
non-lawyer, and that's a relevant email, he can't say, well, I'm not disclosing that email because
will disclose the
Miss
fact the
Loveridge
email was
copied
also
in.
sent to the
Yes,
lawyer. Yes,
yeah,
that's
so
right.
That's not enough, but is it then saying that the lawyer can be required to disclose that?
Well,
email,
I don't know how to put other than that. We say that the multi-addressee reasoning in Jet 2 is an answer to the fact that it appears to be, as said to be, it's offensive that the FRC could find out that these attachments had been sent to the lawyers.
Well, I said towards the end of Mr Lissak's submissions, I thought the case that he was putting was rather simpler. He said, either you look at the email and attachment as a single communication, or you look at it as two separate communications, namely the email on the one hand and the attachment on the other. If you look at the email plus attachment as a single communication, it's privileged. If you look at the email and attachment as two separate communications, the email is privileged and the attachment does not respond to
Yes.
the notice.
I was going to move on to that, Manuel. During my submissions on this point, I haven't heard anyone saying, well, we're not running that. But if that's not being run, I'll move on to
I
the
think
third.
the truth of the matter is, my recollection is that actually when Mr Lisak started on this point, he did make that, but as the submissions progressed, my understanding was it ultimately developed to exactly as my lord has indicated.
I'll move to what your
So we'll
lordship
see what he says.
will be glad to hear is the final submission, which is in relation to that point. Now that point emerged yesterday afternoon, as your lordship observed.
This is the not responding point.
Yes, it's not raised in the ground of appeal, and STI did not seek to argue before the judge the attachments shouldn't be provided because they weren't responsive. Indeed, when the documents in issue, I won't turn you to the letter, were withheld originally on the 18th of... you'll recall what happened was the additional documents were supplied. We weren't told that any documents had been withheld. We wrote saying, have documents been withheld? This is in the context of a privilege hearing the following week, and we're told, yes, they have.
The short point is it was not raised below, and it's not on the ground of appeal, but assuming they can raise it, what is your answer?
Well, we say that their point on single communication is very difficult to square with it. If it's a single communication, how do you reconcile that with the fact that this attachment is not... If they're wrong on that, so if they're wrong on the privilege point related to single communication, then their single communication point means, by definition, that email and attachment are both responsive.
I thought you were going to make a different point, going back to what you started with about you don't know exactly what it is you're looking for, and therefore, in this case, you're asking for the letter or the email and the attachment. It does respond, therefore, to the notice, because that's what the notice asks for.
Well, my lord, yes, that's the
I thought that's what you were
that
going to say.
That is, sorry, my lord. There were two limbs. I didn't say there were two limbs, but that is what is in
Well,
front of me.
I suppose you would say it's the mirror image of the single communication point.
Yes.
It's the other side of the coin.
Yes.
You ask for, I'm not saying you're right about this, I'm just trying to understand the submission.
No.
But you say in your notice, doing the best you can, for this composite, if I can call it a composite collection of documents, which is the email and the attachments. The email, if you look at it as a single entity, it does respond to the notice. Equally on the other side of the coin, looking from the other part of the telescope, the other side of the telescope, it's a single communication.
Yes, the notice
Is it as simple as that?
The notice is framed in such a way that if the email satisfies the specified criteria, then both the email and the attachment do.
That's the truth. Good. Right, that's it. But can I just, the one bit of your submissions I think which I think was among of the, I'm not saying it's the most complicated, but I think we need to nail down very clearly. Can I just go back to this? 'Cause I want to make sure I've really got this. The 1.8 point, the reconciliation of the 1.8 in Schedule 2 and the statutory override. I just want to really understand this because it's a little complicated. If you're correct that there is a statutory override, which of course you don't need the statutory override if this isn't part of LPP at all. So we're assuming it's a Lord Hoffman's technical breach override. if it's a technical breach override, you've explained how it work out. You just refer back to Parry, and you say, look, didn't trouble Lord Denning. He reconciled the two provisions together. That's how you do it, and there's no problem. But that does presuppose that you succeed in raising, and I'm not saying you're not going to be successful, but I'm just trying to analyse it. It's successful in getting to the stage of the statutory, the override for a what's so-called statutory incursion or statutory breach. If the court was to come to the conclusion that you don't get over the statutory override, ignore 1.8, but you don't get to the level of saying necessary implication or reasonable implication. If you didn't get that stage, this wouldn't arise. It only arises if you get that and you have to reconcile that with 1.8.
Or if I'm trying to put, shall I wait, my lord?
No.
Or if the non-infringement principle runs, that there is no infringement of the privilege,
Right.
then which rests on the same underlying reasoning as the technical breach point. We say both routes are reconcilable.
If there's no infringement,
Yes.
there's no problem. They have to disclose it
Well,
because it's not a privileged document.
well,
Right.
but
That's the submission, my lord. Yes, absolutely.
the difficulty is that that's not how 1.8 is worded. It's not worded by saying you are entitled to refuse to disclose documents where the law says you can maintain a claim for legal privilege as against a regulator. What it says is you can refuse to provide documents in the circumstances where, if you were in court, you could refuse to provide documents. So even, I'm not not sure, but even if you're right that there is this regulatory loophole, whatever, created by Lord Hoffman, I'm not sure how that helps you, given that that Article 1.8 doesn't seem to be drafted in a way that gives you the benefit of that.
Well, 1.8. The point of 1.8.
You have to read, in short, that you have to read 1.8 as meaning more or less you can maintain such privilege as the law says you are able to maintain as against a regulator.
Well, the usual rules. It says that the usual rules of professional privilege apply. And my lady, just to take, we haven't been here yet, but it is just worth looking
Well,
briefly.
it doesn't actually say that, with respect.
I've always judged the word with respect, my lord.
Not when you say it.
But my lord, the steps in my reasoning of this, just as a Lord Denning thinks that that's what the provision in the Solicitors Act does. The provision in this Act is materially identical to that. Therefore, I gratefully adopt Lord Denning's
Yeah, no, I
gloss.
understand that. You say that this has been decided by
Yes,
Parry Jones and endorsed by Lord Hoffman.
yes.
Whatever the literal meaning of this
Yes.
thing might be, we should accept this in accordance with the decided case.
We say, my lord, that 1.8 means that any document which a party would not be obliged to produce in High Court proceedings is not obliged to produce the FRC. Therefore, if there is any common law rule which means that a party does have to produce a privileged document in High Court proceedings, that privileged document will also be required to be produced, notwithstanding 1.8. That's the nub of it.
In what High Court proceedings, as opposed to regulatory investigations, would
But also-
STI be
well,
compelled to produce its
well, my lord,
privileged material?
My submission is I don't need to identify those because that is not. This is a standard wording.
Right.
It might as well have said county court proceedings or court proceedings, and in
Well, no, I think because what it's referring to is, as I read it, that is as compared with, say, tribunal proceedings in which the ordinary rules of evidence sometimes don't apply. That's how I read it, as why it specifies High Court proceeding.
Well, my lady, this is a standard
Yeah.
wording, and it's clear. We say what it's doing, what it's trying to do. So, just briefly, to turn you to with some dread, I see from the bench at 1.3 of the authorities bundle. There are various. I'll just turn to one of the standard sections. It's the Competition Act. Privileged communications. A person shall not be required under any provision of this part to produce or disclose a privileged communication. And what the draftsman does there is tries to express what a privileged communication is. And the use of the reference to the High Court is merely a compendious way of referring to privileged communications. So there are various other examples.
I think what you say, I'm just trying to work this out. So, what you said before when you were making your submissions earlier on this was when 1.8 refers to, but otherwise the rules, but otherwise the when does not require a person to provide any information with the entitlement of the provide or produce in proceedings in the High Court. Yes. You're saying that's materially similar to the wording in the Solicitors Act, which refers to a trial.
Yes.
You're saying there's no real difference between that and the trial. And that's the way that Lord Denning reconciled those two together. And I think what you're saying is that Lord Hoffman explains that. Who is the one who says, but it's Lord Denning who says, but otherwise the same rules apply.
And Lord Hoffman must accept that, or that would be a bar to the Parry Jones principle.
Yes. And you say the regulator, the point that's being made is exactly the same for the Denning case, Parry Jones, as it is for Morgan Grenfell and for us. I mean, in all those cases, they were regulators; they weren't in High Court proceedings, and so the actual wording you say is not. Well, it's been explained or applied by Lord Denning and then Lord Hoffman, and so we do so here. Okay, I think that's as far as we can probably get. Any other questions? Any other questions? Thank you very much indeed.
I see the time. I have a few short submissions in reply. I will endeavour to be finished by 4:15.
Very good.
If it's more convenient for the court for us to put these short submissions in writing, we will.
Thank you. No.
As you please. One, just to recalibrate this appeal, we are here concerned, of course, as you realise, with a fundamental substantive right which has no common law exceptions, but which yields to statute. And the one exception that has its statutory origins in the 16th century and has not changed since concerns statutory override, whether express or by necessary implication. The virtue of that approach to this right is that any exceptions to it will be written, they will be or ought to be clear, and they will or ought to be accessible. Yet, secondly, founded on just under 7 lines in one short paragraph in a dictum in Morgan Grenfell, the FRC seek to reshape the approach firstly to statutory construction and secondly to the law of privilege for all purposes, not just for regulatory purposes, on lines of language not adopted by the rest of the panel in Morgan Grenfell, we respectfully submit, given the presence of 3 of them in Auckland and 1 of them in 3 Rivers, Lord Scott in both, Lord Hothouse in Auckland. and where, if the FRC are correct, the issue which is raised by the dictum that they rely upon is not just some passing fancy, some line that can be forsaken and cast aside if they are right. It is a very significant dictum which creates a significant inroad into the absolute nature of the substantive right in question. It is therefore more than surprising, if they be right, that neither in Auckland, nor Three Rivers, nor in any of the other cases since, right down to my Lord Justice Lewison's judgment in Accountancy, is this species of departure from the otherwise inviolable rule noted anywhere by any of their lordships and applied in any of the judgments. The only place it is nodded towards is by Lord Phillips in McKee in a totally different concept and for a particular purpose. See paragraphs 10 and 45 of his speech.
It's also in Sims, isn't it?
Yes, but in Sims, no question as to the rightness of it. My Lord is quite right. It's mentioned in Sims, but they make no attempt to expressly state, they make no attempt to decide whether it's right or wrong. 3. My Lord Master of the Rolls put to my learned friend, during the course of his submissions, perfectly correctly, if I may say so, the orthodoxy, i.e., that there are only two ways to interpret a statutory override. The first is by express language, and the second is by necessary implication. There is no space in our law, we respectfully submit, to invent a third, yet that is what the FRC seek to do. They say, in terms, and they don't hide from it, that the threshold of necessity is lower when the infringement is only technical. They say that where there is a conditional override, to use the language of my lady during the course of my learned friend's submissions, some less standard is sufficient. But this, we most respectfully submit, is not a creature known to law. Whether this is the product of what was described, of course, in a non-pejorative sense, of the tortuous reasoning in paragraph 32 of the dictum passage in Morgan Grenfell, or whether it is, to use my learned friend's way, Lord Hoffman finding a way through the thicket by two different routes, as he put it, to the same end, be it no infringement, use and confidence, or technical only, and thus squaring the circle, as he put it, that the divisional court and court of appeal between them couldn't manage, may not matter. The question is whether this inventive route, if it be such, is compatible with the law. The best way, perhaps, of testing the validity of the thesis propounded by my learned friend is the way that my Lord Master of the Rolls did it, by asking, what is the test? By putting to learned friend that if he's right, how do you determine or measure or fix the applicable standard, whereas you have on the one hand on our submission the certainty of express language in a statute, or necessary implication deduced whether it's in the language of Lord Hobhouse, as we have seen, or Lord Millet, which I shall return in a second, as we have looked at already once more briefly, perhaps doesn't matter, but at least each are able to be defined, relied upon, and applied. My learned friend just says in his best answer, a level lower or lesser than that.
Well, I think you actually said at the end, reasonable inference.
Oh, I'm coming to that, yes, absolutely. He particularised it in two ways. Firstly, very next line in my note, he says it is implicit that a reasonable implication is enough. Now, the concept of reasonable implication is fresh, hot off the presses. It's new today. It doesn't feature in the arguments before. But none the worse for that, it's either a good point or a bad point. But it is, with the greatest of respect, a piece of forensic thinking, typical of a learned friend, quick on his feet. But actually, what does it really mean? it really means nothing more than something less. You've got to find something that is reasonably to be implied into the given statutory regime as creating the necessity for an override. But it doesn't answer my Lord's question that just because the implication may be reasonable, it doesn't help anyone seeking to understand where and when it applies and on what terms and against whom, what it is. But the second thing that learned friend does is he accepted what Lord Millet put it in B, paragraph 59 in his speech, when asked whether he accepted it by my lady. Could I please, I think this is the only reference I take you to, could I just take you to that reference? It's in Authorities Bundle 2, tab 24, paragraph 59, which is at the foot of page 416. Picking it up one line from the bottom, a useful test is to write in the words not being privileged to documents and ask not does that produce a reasonable result or does it impede the statutory purpose for which production may be required, but does that produce an inconsistency or does it stultify the statutory purpose? The circumstances in which such a question would receive an affirmative answer would be rare. Now, the learned friend has accepted that that is correct. It is, in our respectful submission, a most useful passage for measuring what is meant by the statutory threshold and test. It is our submission that there is no answer that is worthy of the description, no answer to the question of what is the test when the other side are asked of it. Point 4, and differently. The FRC posit the situation that confidentiality could be lost by operation of law or choice later. By this I mean, they say that you can have a situation in which the issue of privilege is resolved against this sliding and amorphous scale of theirs, so the privileged materials are gone because you've been able to point to something sufficient to satisfy their reasonable implication, whatever that means. And then you can leave to later issues about publicity, issues about publication of details in a given case, each being matters of discretion for the given tribunal or authority to exercise, with there being no certainty at all as to how they will be exercised. That, in our respectful submission, is an anathema in the context with which we are concerned. It is to postpone the point of determining whether or not there has, for example, been an infringement of confidentiality, a loss of privacy, publicity, a loss of confidentiality, until it's all too late. And it is truly putting, reusing for the second time the clumsy analogy I used earlier on, allowing the tail of consequence to wag the dog of privilege. It is putting the matter all the wrong way round. Point 5, use of the materials. Now, certainly the position has been more than developed by my learned friend in his submissions, particularly since the short adjournment. I'm going to start, please, with the accountancy scheme. Could I please invite you in the supplemental bundle to tab 10, which is the transcript of the hearing below, and page 178 on the bottom right hand side, between F and G. This is as the matter was.
Sorry, this is which page?
I'm so sorry, this is tab 10 in the supplemental bundle, page 178. Thank you very much.
You referred to
I did. I'm not going to read it out again. Merely remind you of how it was put by my learned friend before the judge. Where we've got to now seems to be this. They say they can use the materials, I think certainly non-privileged, and they say privileged, obtained under SATCAR in the accountancy scheme investigation against subject B, the employee of the appellant in this case. Or be able to pass those papers to any professional body that is a member of the accountancy scheme, of which includes all of the main accountancy bodies, as my lords, my lady know. And they can do that through one of the gateways identified by them. But inevitably, that situation must impact confidentiality, adversity, and prejudice. Because the potential use to which the materials may be put is inestimably broader than it might hitherto have been thought to be, were one merely considering it in the context of the audit enforcement procedure. No doubt it was for this reason learned friends used the word indirect about the potential risk for us in their skeleton argument, a point I showed you in our original submissions. But the strange thing is, isn't this the very enemy of the principle which they espouse, which is premised upon a preservation of confidentiality, no adversity, and no prejudice? In other words, the very basis upon which they seek to use the Morgan-Grenfell principle is undone by the very situation which they say may pertain unto their schemes in this case. And as for the corporate reporting review, it's helpful that learned friend took you to the latest version of their undertaking. Don't trouble you to turn to it again. But it may be helpful to remind you briefly to take but a moment in the supplemental bundle to look at what their powers are under the CRR, because they're rather grander, at least in the description.
So what did you want to get out of page 178? Did I miss that?
Oh, it's just the little piece about how they put their case before the judge. That's all, which my lords had already. Thank you. Just to remind you of the reference. Could I, in the same bundle, please, bring you on to divider 25, please? And page 283. And you'll see at the top of 283, picking it up from the foot of the page before, this is under the CRR function heading, which I think you've kindly looked at this page already. But you can see what might be the result of a CRR, according to the FRC, on page 283 at A, B, and C. Now, it is our submission that the potential here for use against adversity, prejudice, call it what one will, whether direct or indirect, is considerable and real. Because what they offer through their undertaking, which is illustrative of the thinking, is that they will or won't do certain things premised on the use of the word solely. Where information or a position solely, as they say in the undertaking on page 297, comes through the very documents with which we are here concerned, then they undertake not to do various things. So, in relation to any documents or any information solely derived from any such documents, etc., etc. But what if, taking my Lord Justice Lewison's premise, what if the case against GT concludes, and then the FRC and indeed the rest of the world have got a published report that is condemnatory of GT for failing to stop or permitting, whichever way around one puts it, statements in the financial accounts? Isn't that exactly the sort of situation in which they will say, well, that's fine then. We will now go on and use that finding, either alone or in combination, so therefore never solely, to bring CRR proceedings against the appellant. And in so doing, this is not some hysterical world flight of fancy at all. I don't think it's how things tend to work, our respectful submission. And if they do that, we can't stop them under the undertaking or anything like it. And the consequences will be the indirect, using their word, the indirect consequence of them having obtained under one cloak materials then used under another. Moving on, point 6 of 10, nearly there. Difficulty created for the FRC of them not succeeding in this appeal. It is, without any sense wishing to be dismissive, nothing to the point. On the FRC thesis, they need this material. Well, whether they need it or they want it or they'd like it, whether it goes further than in fact they'd ever get directly from the auditor because he can't force the client to provide it to him, or it can't force the client to provide it to it, they then get it by going against us directly, and so forth, is really neither here nor there. In our respectful submission, if one applies the test of Lord Millett and the proper meaning of the words necessity, by necessary implication, the convenience or otherwise, the utility or otherwise, whilst not to be taken lightly, and I don't wish to be dismissive of it, is not to be determinative either. In our respectful submission, this is a classic example of a regulator's wish versus the substantive law.
On any footing, we do know that Lord Denning's, the decision at any event in Parry Jones is binding. It's not been overturned. So however you look at it, the decision is binding. And so we know that in that case, if we are giving Lord Denning on Lord Denning's or giving Lord Denning the benefit of the doubt on this, something like that, in the light of the orthodox test, as you described it, of express provision or necessary implication, the decision is only explicable on the basis that the existence of the obligation to produce documents to the SRA amounted by way of express interpretation or necessary implication of the regulations to a statutory override. And so what the question is, and that must be on the basis, that otherwise the scheme couldn't properly work. The regulatory scheme couldn't properly work.
Yes.
The only way you can get there. And so what's being said here at the end of the day, I'm leaving aside for the moment the putting of a slightly lesser test, whether it's reasonable inference or whatever, but taking the orthodox test, what is wrong with the proposition of the FRC advanced today by Mr Simpson that the regulatory scheme will not work unless they can get these documents, and therefore the requirement to produce the documents made directly under statute is to be regarded as a statutory override on perfectly standard principles.
Well, the FRC have been the competent authority for this sector since June of 2016 and have carried out their duties, as one knows from their high publicity to the big cases that they've been involved in, with no problem at all as far as we are aware. This is the first time SATCAR's been deployed. You've not heard from them any complaint. They have got examples backed up of them being frustrated in their purpose. And one reminds oneself of where Lord Millett drew the line between not does that produce a reasonable result or does it impede the statutory purpose for which production may be required, both of which are insufficient, but does that produce an inconsistency or does it stultify the statutory purpose, we submit they fall the wrong side of Lord Millett's line.
But how are we going to determine that? I mean, we're told by Mr Simpson that it would frustrate the statutory purpose. It would be inconsistent.
But my
So
Lord,
how are we to resolve that?
I suppose one resolves it by principle, because one can't do it in any other way, because you've asked 3 or 4 times if there's any evidence for the point and been told no each time. And so the position is that they have accepted in terms, again as you know, that they can't hit the necessary implication threshold in this case.
But I think no, I don't think. I think they put it in the alternative. I think in a discussion with myself, maybe with the other judges as well here. But I think that Mr Simpson did in fact say he relies upon the lesser test, but if he has to, he also says it's a necessary implication.
Well, that is a nuance that is new, if I may say so. None the worse for that. I'm not going to get excited about it. It's 4:15 in the afternoon, but it's
What do
new.
you say about that? We have to deal with that. I mean, that's the submission.
Well, if that's the submission, then first of all, they have singly failed to establish the second part of his proposition, the necessary implication.
Well, you say because there's no evidence.
Absolutely nothing.
Well, isn't also the answer, sorry, but Parliament thought about this and included 1.8 in
Yes.
the provisions,
Yeah.
decided, well, it may make your life too difficult, but we've got to balance different priorities, and you have to do the best you can without privileged material.
Yes, which is absolutely right, and which is why when my lady said before, why isn't 1.8 an answer to this appeal? You're right, it is, in our favour. It puts to the sword this argument.
Yeah, but it's not as simple. Maybe it's not as simple as that. I'm just testing the
Yes.
proposition, because then it would have been an answer for Lord Denning.
Well, first
But
of
it
all,
wasn't.
First of all, one was dealing, of course, at that stage with a very different law of privilege when Parry Jones was decided. And the other thing, which I didn't want to be in any sense quarrelsome with my lord earlier on, when you put to me that Parry Jones is a good law and authority, we respectfully submit it's not actually. We put it in our note at tab 9A in the bundle that I referenced yesterday in the question of precedent that I parked. And I know that you won't have forgotten it, so I didn't go back on the point when you put it to me. But we don't accept that it is still binding, because what is of binding effect is the ratio of the case, and the ratio is disapproved of in Morgan Grenfell leaving just the result. And that is then reinterpreted, and you can't retrospectively confer a new ratio 30 years later, or whatever it was, 20 years later, in a different judgment for a different purpose. So we don't, with the greatest possible respect, without wishing to be in any sense quarrelsome, we don't accept that Parry Jones is still good law at all.
And you say that's all set out where? 9A?
9A, yes, in the note we put in.
Was that the
It's in the supplement. I think it might be in the core. Can I just check? Supplemental 9A, and it's paragraph 17 onwards on page, I think from memory, 142.4.
Yes.
But can I deal with the solicitors anyway? Can I just crave the court's indulgence for a couple of minutes? Thank you very much. The position of solicitors is quite interesting. This is, in our respectful submission from the FRC, a real bootstraps argument. They can't quite get there on their own, so they try to pull themselves up by the bootstraps of the solicitors' regulation provision. The position of solicitors stands apart from the position of the FRC, and they just can't get there by this argument. Firstly, the meaning of the current Solicitors Act, or indeed its predecessor, whether it's sub 6 or sub 11 of section 46, doesn't matter, whichever version of the language is the same, is not for interpretation in this case. And in any way, it's a different act in a different context, in a different statutory regime. And the Solicitors Act there is no equivalent in the Solicitors Act which provides for the right to engage at the disciplinary hearing stage through the lens of privilege. There's no correlation between that and Schedule 2.1.8 in our case. So they are comparing apples and pears. Furthermore, it has been...
Just repeat that again.
Yes, I will. In the Solicitors Act, subparagraph 6 or subparagraph 11, whether you're taking the 1957 Act or the 1974 Act, it raises the concept of a subpoenaed party not producing materials which they would, use shorthand, be entitled to refuse to produce for privilege. But that is at the disciplinary hearing stage. What we're dealing with under this case, in this appeal, is not that stage at all. We're dealing with a much earlier stage, which is investigatory. And it is at this early investigatory stage that Parliament has ordained, through 1.8, that a party, whether it is under subsection 1 or as we are under subsection 3, can deploy its rights of privilege, if I can put it in that way. Whereas in the solicitor's regime, the position is that there isn't that break until you get to the actual disciplinary hearing. There is no equivalence at the investigatory stage because obviously, we would say, by necessary implication.
So there's no equivalent to paragraph 1.8 in the
Correct.
solicitor's regime at the investigatory stage.
Correct.
All there is the old section 46.
Correct.
6, which was at the later disciplinary hearing stage.
Exactly so. Exactly so. And the reason why we emphasise this, I'm sure it is obvious. So there is a danger of over-freighting the point of equivalence that Melinda Friend seeks to deploy with too much, more than it can bear. Which brings us neatly to the issue of Satkar itself. This argument has become, with the greatest of respect to Learned Friend in his hands, incredibly overcomplicated and over-engineered. He has to over-engineer it to make it potentially work. But actually the point is a great deal simpler than he would wish it were. And it is no more than this. Schedule 2, Section 1, subsection 8, applies for two purposes. It applies, and for the last time, might I invite you to turn to it, please, tab 5 in bundle 1, authorities. And page 82 for the prior part, which you've read so many times, so forgive me, I won't read it all again. But you know that it applies to two bodies of entities, people. It applies to those who come within subsection 1, namely the statutory auditor, and under 3, it applies to any other person covered by subparagraph 4, and subparagraph 4b is us. Therefore, if one turns the page to 1.8, one is concerned with a notice under subparagraph 1 or 3, and we're not 1, we are 3, obviously, does not require a person to provide any information or create any documents which the person would be entitled to refuse to provide or produce in proceedings in the High Court on the grounds of legal professional privilege. And the words mean what the words say.
In other words, you can't interpret this paragraph as confining LPP to the auditor's LPP because 1, 3 and 4 and 8, taken in combination, tell you that it extends to the target.
Exactly so. Exactly so. And it is one of the more bizarre corners of the arguments advanced, if I may say so, by the FRC, that they argue a case in this court that the words actually mean the opposite upon their construction than what they actually say. So if you are a public entity under sub-provision 3, because you come within sub 4, and you look at what your rights of retention are under sub 8, you may be forgiven for thinking it allows you to withhold any information which you'd be entitled to withhold in High Court proceedings on the grounds of legal professional privilege. But Learned Friend's argument is to a different effect. he builds in this notion that because the decision in Morgan Grenfell amounts to a reworking of Parry Jones and Taylor, for what it's worth, and because those are decisions of ultimately the High Court, they form an implied part of the test by which you then judge whether or not your privilege entitles you not to disclose but to reserve. And the inwardness of the argument just gets completely lost. And many times my Lord tried to distill to its simple essence what was the argument. And there's not criticism of learned friend forensically at all, just the argument is very difficult that he advances. But again, answer comes there none, because actually the simple answer is, when one's dealing with a fundamental substantive right like privilege, is in the language. It means what it says. And the bizarre thing is that a public interest entity reading this on their view would have to read this as meaning probably the opposite of what it says. May I a penultimate, I think it is, I've got 2 more points if I may. The first is ground 4 in the CAA case. We don't go further than the summary of our position of my Lord Justice Lewison of yesterday afternoon and repeated again today. And if we went further earlier on, that's my fault and mine only. 2 things I would just say. There was a little excitement on our side of the court when my learned friend said that we've only now, for the first time in this hearing, said that the attachments are not responsive. He obviously overlooks the skeleton argument of October of 2018, which is in the core bundle. I think it's tab 2, in fact I've separated mine. It's our skeleton argument in any event for this appeal.
You showed us that.
I did, where we said...
for the avoidance of doubt.
Exactly, exactly. And the second point I'd make is this, that as regards the CAA case, for reasons previously given, which I wouldn't dream of repeating, we stand by the proposition that the decision in that case in this regard is obiter. Lord Justice Hickenbottom effectively says so in paragraph 106, and is the judgment of the court on that point. He says in terms, it's not going to be dispositive of whether or not the documents are privileged, seems a pretty good clue. And secondly, the 4 propositions in paragraph 107 of the judgment, we have no difficulty with any of them, as I explained in my earlier submissions. So we don't accept this in any sense helpful to learned friends. And the very last point I just make is this, and it's merely just a correction of balance, I hope, no more than that. Just after the short adjournment today, my learned friend, responding to something that my Lord Justice Lewison had said, that another route to in the solicitor's context to the privilege point might be consent, which is back to a waiver exchange that I think we had during the course of my submissions. In other words, an implied consent to a solicitor providing documents amounting to a waiver. And my learned friend said that that applies to the FRC too. Well, I'm sure he didn't mean to overstep the point, but it will be remembered that the waiver issue, the arguments he aired again today, were the arguments he aired before the judge below. He, under the waiver banner, he lost those arguments. You can see the terms of the argument if you want some other time in the judgment in paragraph 54. And there's no respondent's notice, as you know, and so the point is no longer live in this case. My lords, my lady, those are my submissions, and thank you for your indulgence.
Can I just be clear?
Yes.
When you said that you are now going no further than how my Lord Justice Lewison summarised your point on ground 4, do I understand that you're not pursuing the trend of advice ground then?
Only as a tender to the main vessel, which is the document, individual documents which are attached to an email in their separate form will be disclosable in 99.9% of the time if they're responsive. but they will be shorn of the indication that they are connected to the giving of legal advice. So the document itself, if it is
Yes.
so subject to that small point, yes. Those are our submissions. Thank you very much.
We're very grateful to both
Thank you.
council.
Oh,
and to
just
those-
one factual correction, if I may, very briefly. My friend said there was no evidence before you in relation to difficulties caused to the FRC.
Yes.
In relation to this case, there is a statement of Mr Salcedo at supplemental 2, and paragraph 20 deals with the difficulties in that.
Supplemental bundle two.
And it's paragraph 20. Supplemental tab 2, statement of Mr Salcedo, paragraph 20.
We're very grateful to all council, both those leading council and those behind you, who I'm sure have contributed greatly. And we will consider our judgments in this matter. When we do send to you for review, please do send in corrections solely on grammatical and textual matters only. We don't wish to hear any further submissions orally. Any further submissions you wish to make should be in writing. Please agree a form of order when you get the draft.
Thank you very much indeed. Thank you.
Otherwise-